Here. Happy to see that you are interested in this very niche subject and that you will learn a lot about NFTs. My setup here is a bit awkward, so you will probably see me looking up, unfortunately. And yes, my lightning is not so good. I'll try to make it better. Okay, just to introduce myself, my name is Morana. I used to be a lawyer. Now I'm an in-house lawyer leading all legal affairs and regulatory and compliance affairs at Electrocoin. Electrocoin is one of the biggest Croatian cryptocurrency exchange offices and custody provider. We actually do not deal with NFTs. We only deal with cryptocurrency, but still, this is blockchain. The technology is the same. And of course, I believe I can give you some basic insights regarding the legal issues around NFTs. I know you had a lot of fun with Ivan. Ivan is great. I wasn't able to listen everything, but I caught the chat with Pauline, and that was probably very, very great for you and practical. I hope you now have a wider picture regarding the technology behind the NFTs and how they function. My lecture will not be so practical, unfortunately, because those are legal issues and they can sometimes, I know, be a bit boring. So I tried to make it as basic and as easy as I could for you, just to give you some basic point of view you should have in mind while when dealing with NFTs. Okay, so let's start. First, I would like to explain the definition of NFT from the legal point of view. And I will say it immediately, there is no official legal definition of the NFT. We still do not have any specific NFT regulation. I'm speaking for the European Union regulatory environment. But basically, we can say that the definition is that the NFTs are assets like a piece of art or digital content or video that have been tokenized using blockchain technology. These tokens are then being unique by identification codes created from metadata via the encryption function. And then they are stored on a blockchain, while the assets themselves are stored in other places. So the connection between the token itself and the asset is what makes them unique. That's why we call them non-fungible tokens. So the important thing here to know from the legal point of view is that NFT is based on the asset and the token. So asset plus token equals the NFT. You will see why this is very important afterwards. So now that we know there is a kind of a definition, we should see whether there is any regulation that regulates NFTs specifically. As I said, in Europe, there is no specific regulation that governs only the aspects of NFTs. The way we understand them largely depends on their use and purpose and the unique characteristics of each token that you make. So, to figure if there is any law to apply to them, we first need to understand these aspects and the characteristics of the NFT itself. So, maybe a lot of confusion comes from trying to determine what ownership and rights they give to someone, the NFTs. So while there isn't a specific set of laws just for NFTs at this moment, because of that fact, we have to look at various existing laws from different countries here in the European Union to make sense which law and which rule applies to them. The applicable laws can vary a lot depending on the original asset that the NFT represents, etc., etc. So this could be something like IP, intellectual property rights, or maybe transferring ownership rights, or the practical use of the NFT itself. So the point is, NFTs are very global, as you know, but the regulation is still very local, and it varies not only throughout the European Union, but throughout the whole world. In the past times, in the last year here in the European Union, we have a new regulation that regulates the markets of crypto assets. This is called Markets in Crypto Assets Regulation, in short, MiCA. And this is the first regulatory framework in the European Union for operating a business dealing with cryptocurrencies. This regulation regulates two parts of the market. One part is issuance of the crypto assets, and the second part is offering services related to crypto assets. So, as NFTs are also backed on blockchain, on the same technology that cryptocurrencies and other crypto assets are based on, we should first take a look whether this regulation may be applicable on NFTs. For that, we need to take a look at the definition of the crypto asset itself. So, MiCA states that a crypto asset is a digital representation of a value or of a right that is able to be transferred and stored electronically using whether distributed ledger technology or similar technology. As we can see, NFTs are also a digital representation of a value, but here it is important to notice which value. What does NFT represent? Does it represent, I don't know, currency? Does it represent any material thing? Generally, it represents a digital art, but this digital art has a value, but does it represent the value or the art? To see further whether any definition of crypto asset could apply to NFTs, we will take a look at the definition of tokens itself. For the first time here in this regulation, we now have a classification of crypto assets on three types of tokens. Those tokens are asset reference token, e-money token, and utility token. Asset reference token is a token that maintain a stable value by referencing another value or right, or a combination thereof, including one or more official currencies. This means that you have a token on blockchain, which value depends on maybe some official state currency, for example, euro, or maybe some material thing, other value, for example, gold. We here now on the market, we have one, maybe two types of asset reference token. One of them is called Pax Gold. And this token tries to maintain a stable value by referencing the value of gold on a real market. Next, we have an e-money token. E-money token is basically e-money. This is a crypto asset that maintains a stable value by referencing the value of one official currency. And then we have utility tokens, which are type of crypto asset that are only intended to provide access to a good or a service supplied by a certain entity or the issuer of the token. As you can see, if you think a bit, none of this definition is really applicable to NFTs. Why? Because the point of the NFT is not to maintain a stable value by referencing any official currency or any other value or right, or maybe, I would say maybe, they are sometimes intended to provide access to a good or any service, but in a very small number of cases. So I would say that from those definitions, it is clear that market in crypto assets regulation never intended to regulate NFTs. That doesn't mean that the regulator, once they were drafting the regulation, was not aware of the existence of NFTs. They also they also thought about them. They thought about how to regulate them, but they decided to exclude them from the scope of this regulation. And they explain it very well. It states in MiCA that this regulation should not apply to crypto assets that are unique and not fungible with other crypto assets, including digital art and collectibles. Why? Because the value of such unique and non fungible crypto asset is attributable to each crypto asset's unique characteristic and the utility it gives to the holder of the token. So they cannot be generalized. They are not fungible. But they can be traded, but the regulator says they can be traded on the marketplace and can be accumulated speculatively, definitely on the market, but they are not interchangeable, and the relative value of one crypto asset, such as NFTs, in relation to another, having in mind that each one of them is unique, cannot be ascertained by means of comparison to an existing market or any other equivalent asset. They are definitely not, in that sense, similar to cryptocurrencies, which are fungible. Yes, they are traded speculatively, but they are fungible and their value depends on the demand on the market. So, this is why the regulator decided to exclude NFTs from the scope of this regulation. But there is one thing that is important to understand. Our regulator here in Europe has a special approach on regulating new technologies and things that are not very well known to the people who writes the regulation. This principle is called substance over form. It's a general legal principle while drafting a regulation, which means that it doesn't matter how something is called. What is the matter is how it works. So it is important to understand that the regulator here said if the issuance of non fungible tokens, NFTs, is in large numbers or series or collections, they could be and should be considered an indicator of their fungibility. So the thing that they are unique is not sufficient enough if they are issued in large series or collections to make them non fungible. So what's important to understand that you have to think about what was the purpose of issuing this NFT, what was the goal you're headed. If you are interested in issuing a large number of NFTs just for retail purposes, just for selling them, they can maybe fall under the scope of this regulation because then you could maybe be a subject that provides an offer or offer to sell and to buy those crypto assets on the market. So this is, I think, very important for you to understand. For the purpose of this workshop, I believe that nobody here has the intention of issuing NFT in large numbers just for the purpose of wholesale and retail sale. So I would say that this regulation will not be applicable. But if this is the case, then you should consider this regulation and you should see which terms does the regulation sets out for the subjects who intend to issue NFTs and to offer them to public. Next very important thing is to think about whether the NFTs are maybe financial instruments or not. Why? Because financial regulations are hard. So, Mika says also that the exclusion of crypto assets that are unique and non fungible from the scope of this regulation is without prejudice to the qualification of such crypto assets as financial instruments, meaning that if there is a possibility that one NFT is to be identified as a financial instrument, MiCA will not apply, but definitely other regulation that regulate financial instruments will apply. So we are now looking at the Markets in Financial Instruments Directive, which is a directive and regulation that regulates financial market and financial instruments. So for an NFT to be classified as a financial instrument, an NFT should fulfill, let's say, five typical terms from which we derive a definition of a financial instruments. So it is important that they are not to be considered transferable securities, which then makes them a type of investment that can be traded in financial markets. So to be classified as a transferable security, NFT would need to fit into a certain category of investment. This category of investments, or in short, class of securities, aren't much clearly defined or explained in this directive. So all EU member states can maybe interpret it differently. But typically, investment instrument, a class, implies something that can be exchanged or replaced. Well, since the NFTs are unique and cannot be interchanged, they generally wouldn't fall under the category of transferable securities as per the directive usual interpretation. So we can maybe safely say that I don't know what must happen, but I'm pretty sure that any European regulator will not classify an NFT as a financial instrument yet. This would be an extreme case. So now that we shortly entered those two regulations, I think this is really very important to understand because the regulation in financial markets and now in crypto market are very, very heavy, very, very heavy to implement and to understand. So it is very good to know and to understand when they are not needed to be implemented. So uh, the problem with the financial instruments is, as I said, that each EU member state may implement the directive differently. And because NFTs can vary greatly in nature and in use, each NFT might need to be looked at individually to decide if it falls under this directive. So again, substance over form approach and a detailed examination of each NFT is really necessary to determine its classification under the EU law, whether it is financial instrument or crypto assets. But as I said, it is pretty sure we still haven't had a case of proclaiming an NFT as a financial instrument or crypto assets in terms of MiCA. Okay, another very heavy regulation that regulates financial market as well as crypto asset market is anti-money laundering regulation. Do we have any obligations regarding anti-money regulations if we issue NFT? Well, uh, a global anti-money laundering watchdog, a body called FAT, Financial Action Task Force, issues recommendation for application of obligatory measures for anti-money laundering. Those recommendations apply to virtual assets and virtual asset providers, meaning the subject that offer those assets on the market. So uh, those recommendations define a virtual asset as a digital representation of value that can be digitally traded on or transferred, similar to the NFTs. But the FATF said by themselves, NFTs being digital assets that are unique rather than interchangeable and that are in practice used as collectibles rather than as payment or investment instruments are generally not considered to be virtual assets. As I said, Mika transferred this definition and this uh, understanding of the definition of the virtual assets from FATF to its regulation. So now it is generally considered that NFTs are not virtual assets and are not in the scope of any specific regulations in the EU, which is good for now. We will see what will happen further. I will again say that also, FATS says that it is important to consider the specific nature and characteristics of the NFT and its function in practice, because maybe some standards FATF issues can cover those NFT regardless of the description used. So, substance over form. Some NFTs may be used for payment or investment purposes in practice, but others are digital representation of maybe other financial assets that are already covered by FETS standards or other financial regulations, such as securities. So, in any case, and the potential use of NFT for the illicit financial activities, FATF remains and continues monitoring the market and will keep its recommendations under review. So we can maybe expect someday for FATF to take a stand that NFTs are now a part of a wider market of crypto assets and that issuers of NFTs are obliged to apply anti-money laundering measures in their businesses. But for now, we are still safe. Okay, so now that we took a short dive into the possible regulation that could be applied to NFTs, uh, we will shortly take a look what about the intellectual property rights in relation to NFTs. I think this topic is most commonly referred to NFTs when it comes to law. What about intellectual property? So I presume that you all know what intellectual property is, as you're artists yourself. So, IP refers to a creation of the mind, such as inventions or literary and artistic works, designs and symbols, names and images used in commerce. There is no specific definition of IP in general. So, this is something that you can find on the internet. It's not from any regulation, specific regulation. IP is protected by law, which enable people to earn recognition or financial benefit from what they invent or create. And this is a way to keep balance between the interest of innovators and the wider public interest. The IP system aims to foster an environment in which creativity and innovation can flourish by protecting the artist's right. So, which IP right is most applicable to NFTs? We can say when it comes to art, that's a copyright. Copyright or author's right is a general legal term used to describe the rights that creators have over their literary and artistic works. Works covered by copyright range from books, music, paintings, sculpture, films, computer programs, databases, advertisement maps, and technical drawings. Copyright protection extends only to expressions, excuse me, and not to ideas, procedures, methods of operation, or mathematical concepts as such. So only what you create and not the way you create it is your IP. So copyright may or may not be available for a number of objects such as titles, slogans, logos, depending on whether they contain sufficient authorship behind them. In the European Union, legislative framework for copyright is very complex. There is no unified regulation. We have 13 directives and two regulations that are harmonizing the essential rights of authors, performers, producers. But each member country transposed those regulations that are rendered on the EU level into their national regulations. So, unfortunately, we do not have a unified frame. We only have theoretical point of view, which is same for all EU countries. So, what is important to know about the obtaining your copyright? You obtain your copyright automatically upon creation of a work. You don't need to register or to comply with any regulation or any formality. Once you create your work, you are the sole owner of that copyright over that work. So, the fundamental principle of formality free protection is guaranteed in Article 5 of the Berne Convention, which is the convention that governs the right regarding the IP. And of course, in many other international treaties and regulations in the field of copyright and related rights. So you don't have to register your copyright once you uh, create your work, but you can maybe do it voluntarily. And that voluntary registration is an integral part of many national, on EU country levels, national copyright systems. So those systems vary a lot from country to country. On the European level, we have a body authority called European Union Intellectual Property Office, which deal with intellectual property rights. And with that body, you can register your intellectual property. Unfortunately, that's not possible for copyright. You can register, for example, a trademark, a name, maybe a slogan or something, but your work itself, that's not possible to register for now, because that's the whole point of copyright. Once you create a work, it's yours. You don't really need to formally claim it. And another organization also that worldwide deals with the intellectual property is World Intellectual Property Organization. You can find a lot of infos about all types of intellectual property and the rights they give to artists on their websites. So, what rights does intellectual property and copyright gives you? First, you have economic rights. Those rights allow the owner to derive financial reward from the use of their works by others. And then you also have moral rights, which are protected, and they protect the non economic interest of the author. So it is important to know that you can protect your your work and you can monetize your work because the copyright gives you economic rights. So, most copyright laws state that the rights owner has the economic right to authorize or prevent certain uses in relations to a work or, in some cases, to receive remuneration for the use of their work. The economic rights owner of a work can prohibit or authorize are reproduction in various forms, such as printed publication or sound recording, its public performance, such as in a play or musical work, its recording, for example, in the form of compact discs or DVDs, broadcasting by radio or by any other mean, cable or satellite, its translation maybe into other languages, and its adaptation, such as a novel into a film screenplay, for example. Examples of widely recognized moral rights include the right to claim authorship of a work and the right to oppose changes to a work that could harm the creator's reputation. So, you solely have a right to manage your copyright of your work. You can protect your economic rights and you can protect your moral rights, and they are protected by regulation imposed in each EU country in their national regulatory frameworks. So now, to see a bit, to go a bit deeper, we should discuss about the thing, who owns the intellectual property when creating an NFT? Now, we should go back when I said, what forms an NFT? NFT is asset plus token equals the NFT. So, you tokenize the asset so that you can get an NFT represented on a blockchain. What kind of asset that is, and who owns that asset? The owner of the asset could be the creator of the NFT. For example, you are a photographer and you have your own work, pictures, and you digitalize them, you tokenize them, and you form an NFT. You are the solely owner of your work, of your photograph, of your digital art, and of your NFTs. And you have the right, you have your IP rights, and you can do with them whatever you like. You can transfer them or not. But that is not always the case. The owner of the IP rights on the asset that has been tokenized to form an NFT is maybe someone else. So, while a person who is an NFT owner may legally own the NFT itself, they may not own the rights to the original content or artwork it derived from. I believe Ivan said a lot about the technical aspects of NFT and how it is made. You will have a workshop tomorrow to try to make it by yourself. But legal wise, it is very important to understand that the holder of the IP or this ownership of the asset that is used to form an NFT can be someone else, not the person who issued the NFT in itself. So, when it comes to transferring those rights, NFTs may include licensing agreements or licensing rights. So, to put it like this, with this analogy, while an asset is used to encode the NFT to make a unique representation of that asset, NFT is not usually, unless there are terms or it is encoded in a smart contract in the NFT or in any other associated terms of sale, the asset actually itself. So NFT is not the asset itself. For example, to have an analogy, if a collector owns a physical limited edition print, the collector would own the physical print itself, but would not usually own any proprietary rights in the original artwork. So he would just have a copy. So this is an important distinction, which is often being missed while discussing NFTs. So that intends to incorrectly suggest that ownership of an NFT amounts to some form of ownership of the underlying asset. But that is not always the case, and you have to have that in mind. So, what is then the relationship between the NFT and the underlying asset? Well, in a physical world, an artist would sign the physical print and include a print number. For example, 1 of 5, 1 of 10, 1 of 100. And that artist signature and the print number are not the artwork itself, but a mean of authenticating that artwork, signing that really is his artwork. In the NFT world, an NFT represents the digital form of the artist's signature and the print number that is associated with the underlying asset. Or the NFT is linked to the underlying asset by the digital work itself, if it is not a physical asset, or virtue of a copy of the underlying asset that is encoded in the NFT, which is really not very common, or what is most common, that the NFT contains a code that links to or can be used to identify the digital copy of the artwork or the underlying asset. This is called the hashing. I'm not sure, maybe Ivan explained it. So this is the most common situation when it comes to NFT, that they are encoded in a way that there is a link between the NFT, and that link can identify the digital copy of the artwork or the underlying physical asset itself. That's the most common situation. So that's the relationship between the asset and the token itself. What about the IP rights when transferring the NFTs, selling, buying, or donating, whatever? So the IP rights must be assigned in writing without any express written terms stating otherwise, either whether it would be in a smart contract itself or sideways in any other written terms. The transfer of the IP rights will not happen automatically on a sale of an NFT. This is also very important for you as authors to know. So, when it comes to asset, it is very not usual, but NFT seller can sell both the NFT and the underlying asset together. Then the NFT can be used as a digital proof of ownership. So, for example, you have a physical artwork, a painting hanging on your wall, and you decide to issue an NFT, to make an NFT representing that painting, but only in order to provide a future buyer a digital proof of ownership. But still, you will have to sell that painting, picture, whatever, any physical asset physically. You will have to have an agreement with the buyer, and you will have to give the painting directly to him in his hands physically. When it comes to NFT, everything is, of course, digital, and that is why the hashing function works to connect the NFT to the artwork or any other asset you are dealing with on blockchain, whether you are selling it or collecting it. So, when it comes to the questions of transferring the IP or the asset, we have a very we have a few maybe for you interesting examples of how it is done. For example, Nike uh, had a patent in 2019 for a system called CryptoKicks, where Nike tokenized actual ownership of shoes by linking an NFT to a physical shoes. This is a situation I was talking about with a painting on the wall. So they issued NFTs representing the real physical shoe. So you could buy an NFT of that sneaker, and you would use that NFT to prove that you actually bought those sneakers, that you are their owner, and you could collect them physically. So this is a rare example of connecting, I would say, real world asset, physical assets with NFTs on blockchain. Not very common. So, as I said, the most important thing is to know that the NFT itself is being transferred using blockchain technology immutably. But the IP rights are not always transferred immediately with the sale of an NFT. They have to be transferred by written agreement, whether it is a license that will be digitally represented in some way with along with a sale of an NFT, or it will be in a real world, in physical presence of two parties who are parties of that sale purchase agreement. So this is why artists and issuers of NFTs are licensing intellectual property rights in the underlying assets. So the most common approach is for an NFT seller and issuer and for an IP rights owner to license use of the intellectual property rights in the underlying asset to the purchaser of the NFT for certain purposes, whether that could be further sale or further representation, I don't know. So this is the most common approach. Someone who issues an NFT that represent a digital artwork or any other underlying asset, of course, has to have an agreement with the IP owner for transferring those rights for the purpose of further monetization and selling the NFTs. That license can be set out in the smart contract on which the NFT is based, or in a separate agreement between the seller and the purchaser. So the purchaser's use of the underlying asset can be as open or restrictive as the rights owner chooses. So it is only your choice how many rights and to which extent and in which scope you will transfer to the buyer, to the next person you are offering your NFTs. For example, we have CryptoKitties who are very popular NFTs. So their license permits the owner of the NFT to commercialize the kitty, provided that such commercial use does not result in earnings of more than $100,000 per year. So, as you can see, the author themselves restricted this commercial use to a certain amount. Other example is also NBA Stop Shots, very popular NFTs also. Their license grants the owner of the moments, as they are called, those NFTs are called moments because they are pictures of famous players. Uh, the license grants a use, copy, and display of that moment, but does not permit the owner to reproduce it, distribute it, or otherwise commercialize that moment. So this is basically only a collectible item when it comes to this kind of NFTs. While the CryptoKitties are possible to be commercialized in some other way. What about the markets where you sell your NFTs? Okay, markets are platforms for selling and buying NFTs. Once you issue an NFT and put it on a market, you should take a look at their terms of service, whether maybe the market itself has some IP rights stipulated in those terms. So, for example, OpenSea, the largest marketplace for NFTs, in their terms of service, say that by using this service, in conjunction with creating, submitting, posting, promoting, or displaying content, or by complying with OpenSea's metadata standards in your metadata API responses, which you need to issue an NFT, you grant us a worldwide, non-exclusive, sub-licensable, royalty-free license to use, copy, modify, and display any content, including but not limited to text, materials, images, files, communication, comments, feedback, suggestions, ideas, etc., that you submit or post on this service. Why? Why is this? Because, of course, without transferring your IP rights to OpenSea as a marketplace, they wouldn't be able to market your NFT. They need to have the right to display your NFT in order to put them on a place where is it where they are exhibited for the purposes of sale. So as you can see, this is a way of transferring your IP rights, but of course, this is only for your purposes and only for your intention of selling your NFTs. So, as I said, it is very important to see where do you trade or where do you put your NFTs on sale, and to check those terms of services to see what kind of which scope of rights are you transferring to that marketplace. You should really read those. I know it could be boring, but that is very important. So as you can see, these are some of the NFTs from the OpenSea market space, and you can check each one of them in their value, market value, and you can make an offer of how do you think they're worth. So then, further, another very, very important thing, proof of ownership. Uh, who owns the NFT and how do you prove that? Well, NFT include proof of ownership in their unique metadata in the smart contract, of course. But, however, this doesn't equate to ownership of the original artwork. Again, as I explained it earlier, the asset itself is different from the token itself. So, this is proof of the ownership only of the token. The creator owns the copyright of the original work. Again, I cannot stress this enough. It is very important to differentiate those two things. So, since the transfer of ownership is digital, if the NFT gives you right to own actual physical piece, one should check who possessed it in reality. So, as I said, the purchase maybe is digital, but if the underlying asset is physical, then you really should check where that asset is and who actually holds it and who possesses it. The use case should be that the underlying asset is in fact digital art, because it is the main function of the NFT to be everything to be digital. So NFT then contains a code that links to or can be used to identify that digital copy of the artwork. As I said, that is called hashing, a technical function linked with the creation of the NFT itself. The hash in the NFT does not give the purchaser of the NFT the ability to possess the digital file that the NFT relates to. So, the purchaser will still separately need a copy of the digital file in addition to the NFT. This is also very, very important. The fact that you have the digital representation of any digital file in a form of an NFT does not mean that you have that digital file itself. If the purpose of the NFT is to transfer the IP rights and the ownership of that digital file, also the purchaser will still need to check where that copy of that digital file is and where that copy can be found. That's separated from the transfer of the NFT. As I said, the transfer of the NFT is done by blockchain, and digital file can be stored otherwise and can be transferred by any other mean, not using blockchain technology. So, in that case, the purchaser should consider where the digital file will be stored and who will be responsible for maintaining it. In some cases, the digital file itself is hosted online, and the NFT would then contain a link that points to the web page where the digital file is hosted. But that doesn't need to be the case. And the other thing should be also checked what assurances the purchaser has that the digital file is going to continue to be hosted on that web page and that the file that is hosted there is not going to be altered or it's not going to vanish. All of this should be included in the terms of sale of the NFT or in the smart contract in the NFT. So definitely check the terms of sale when you are in a position of a buyer of the NFTs. And of course, the smart contract if you are able to understand the way they are functioning. Okay, so now theoretically we explained the IP rights. So what about the economic rights that IP right give, gives the NFT issuer? Of course, the only thing, royalty. A royalty, a legal definition of a royalty payment is that's a payment made by one party to another that owns a particular asset for the right to ongoing use of that asset. So, meaning you can monetize your work by reproducing it and selling it, and you will have a percentage of that sale for the purpose for the transferring your IP rights to the next person. So royalties are typically agreed upon as percentage of gross or net revenues derived from the use of an asset or a fixed price per unit sold of an item of such, but there are also many other modes and metrics of compensation. NFTs here open up a potential new revenue stream for asset owners as it is possible to code an NFT smart contract to make a royalty payment automatically to the original NFT seller on each onward sale of the NFT. So this is also very important. You can uh, program your NFT in the smart contract to give you revenue from any future sale of your NFTs, and this will happen automatically, of course, via blockchain. Then you have to have some cryptocurrency, of course, and wallets and everything, all other infrastructure that you need for receiving payments on blockchain. So, who gains, as you can see, the creator from selling NFTs to any buyer and reselling to other buyers. Creator will earn a number of percentage on the sale price if you decide to apply your right to royalties. Okay, so another important thing to consider here is the potential infringement of your intellectual property. Uh, there is no known practice here yet, of course, because the whole space is still new. But there are maybe two main types of infringement that may arise as a result of the unauthorized minting or issuing an NFT relating to a digital asset. First, this is the infringement of the reproduction rights. So, if an NFT issuer restricted those rights against reproducing or copying his work, if someone copies it and reproduces it, that will form an infringement of the reproduction right. Then we have an infringement of the communication right. For example, if an author restricted against communicating copyright works to a new public, not originally envisaged by the copyright owner, if somebody communicate that work to a wider public, not authorized by the copyright owner, that would form an infringement of the communication right of the IP owner. Well, with the respect to the reproduction right, if the NFT includes a digital copy of the asset, there is potential for this to form and to be an unauthorized reproduction that may amount to infringement of copyright. But in circumstances where there is no reproduction of the underlying asset in the creation of an NFT, there would be no infringement. So the important thing is that the NFT itself is not a reproduction of the underlying asset, but only represents, for example, digital ownership or similar. With respect to the communication right, the minting of an NFT linked to an underlying asset is very different act from that of making that asset available in a new form. So if the NFT does include a digital copy of the asset, the act of minting the asset may amount to a communication to a new public that was not firstly envisaged by the copyright holder. So these are maybe very theoretical examples of what could happen when it comes in of terms of potential infringement. But they are very arguable and very questionable at this moment, as we still, as I said, do not have any specific practice regarding this issue or specific regulation that deals with specific circumstances of the technology behind the NFTs and the way of issuing them. But you should be aware, of course, of those possible situations in order to protect your own rights. So, how do you come to enforce your right if an infringement really takes place? So, if you have a business and you issued some NFTs, the only thing you can do your best at this moment is to monitor NFT marketplaces. You can have watch notices in place that could extend to key marketplaces so that you can maybe see whether someone copied your work or the digital file of your work and issued an NFT, and in that way infringed your IP rights. Maybe you also need to check miners who do not have authorization to mint an NFT linked to the business's underlying asset, which is really, really, really hard. But the best starting point are always checking out the marketplaces online to check all NFTs to see whether there is any infringement of your right or of your work. So we came really quick to the end. I don't know if I was very fast or boring. But to conclude, from the legal point of view, what you should be aware when issuing and dealing with NFTs. First, be aware of the characteristic of your NFTs and try not to fall under the scope of any regulations I talked about, so that you do not have that regulatory burden on your shoulders. Then make sure you don't, as I said, don't fall into scope of some applicable regulations. You need to then understand your intellectual property right, and you need to regulate it once you are selling your NFTs. Make sure you monetize your work through your royalties and watch for the potential infringement of your rights. Those are the 5 things you should have in mind if you are meaning to issue your NFTs, to put them public in a marketplace, and to make any new profit out of it. So, with this, I will conclude. This is, I know, very heavy topic, and probably maybe not the not interesting one for you. Uh, Zara, I think we can have a short break at this moment, and then after the break, you are free to ask any questions you would like. I will try to understand any questions you have.
We can
That's okay?
Yeah, we can either do it that way, or we can maybe they can pose the questions in the Q&A section in the Telegram, and then we can.
Sure. Or maybe we can have questions now, so finish earlier.
Yeah, I
Whatever,
think that's maybe better.
whatever you girls like. I know it's late and everybody's tired.
Okay, if you have any questions, pose them now, and we will answer within the next 5 minutes.
You can also always send question in the Telegram group or to my email, whatever. I'm available.
You have a new message in the chat. Just need to scroll down. Okay, if any of you come up with any questions later, make sure to post them in the Q&A section of the Telegram group. Morana will answer it. Just tag her Telegram account so she can see it. Okay. Thank you all.
Oh,
That
okay, I can
concludes
see some.
the.
If you wish, I can maybe answer some of those questions now. What about taxes? Christina asks about taxes. Are they relevant somehow? Not, I can only talk about the Croatian regulatory setup. At this moment, there is no taxation for the purchase and selling of NFTs. At this moment, of course, we have no idea what tax authority will come up with next, because they are not considered to be, as I explained, any kind of virtual asset. So when you sell virtual asset, you gain capital gain, which is prescribed by law. For now, for NFTs, there maybe could be, I don't know, not a capital gain tax, but an income tax, but that should be controlled by the tax authority. And for now, we still have no cases regarding those kind of situations. That was the only question, I think. Okay, girls, if you have no questions for now, see you tomorrow.
Thank you, Morana, so much, and see you all
Hope
tomorrow.
it
I
was
will send you
informative
the
enough.
materials and recordings either tonight or tomorrow morning.
Okay.
Bye.
Bye all. Bye, girls.